Hello, I'm Stephen Brown. I'm an attorney with Reddy & Newman PC here in Houston, Texas. Along with me is our counsel for litigation, Jonathan Wasden. John, we see a lot of cases, especially coming from that February 22nd, 2018 policy memo that USCIS put out, where we've seen more denials on the employer-employee relationship. And that's kind of structured in two ways. Underneath that employer-employee relationship heading, you get that the company has the right to control, and then the availability of work, the third party at the third party offsite employment. And we see those two flavors. And we've seen what USCIS wants are contracts between all the layers. They want letters from all the layers, the end client acknowledging the right to control. And sometimes you can't get those contracts. They're not parties to it, or that purchase order, they're not parties to. And so we've seen denials on these, especially when it comes to the cap cases. What are our alternatives? Because I know if I get a denial for a cap exempt case, it's easy for me to refile. We'll figure it out through the agency. For a cap case, I'm kind of stuck where that person's got one shot at it once a year. Now I've got to hope he or she gets reselected and readjudicated. So what are my options for those cap cases?
You're absolutely right. The approval of your cap H-1 is huge. It's almost like a property right or a vested property right, because it gives you so many benefits and long-term benefits. So preserving the chance to have that is key. So what we're looking at right now is we're prepping a case that we'll file a large case together where we're challenging the employer-employee relationship decisions. And we'll be filing that in federal court to preserve those cap H-1B visas and make sure they're still available.
Now, when you say still available, I mean, are they going to disappear? I know that there are alternatives, that's a possibility, right?
Yeah.
That through the way that it's written.
Technically, the way that it's written is those things poof once the fiscal year is gone.
And can they go back and reassign them too, or do they just disappear?
Well, they're supposed to, what they have the ability to do, so they pick 110,000 in the lottery, right?
Right.
They approve 85,000. So built into the system is they're holding off on a certain number of these just in case you're not approved, then you can reassign that visa to somebody else.
Okay.
So what they're looking at is potentially reassigning your lottery cap that you successfully won in the lottery to somebody else when your case is denied.
Wow.
So to prevent that from happening, we're looking at filing a lawsuit with a preliminary injunction to stop that.
Okay. And that preliminary injunction would maybe stop them reassigning these numbers or getting rid of these visas. And then what about the lawsuit in general? If I can't get that purchase order, that contract between the vendor and the end client, what are you going to tell me here?
It's highly doubtful, in my mind at least, that requirement is even legal. So, especially in light of a recent Supreme Court case that came out that dictates how agencies are supposed to treat and interpret their own regulations. And what that Supreme Court case says is when an agency's regulation is clear and not ambiguous, that they're bound by the language of that. And if you look at the definition of employer-employee relationship in the statute and the regulations say you're an employer if you can hire, pay, fire, or otherwise control.
Boy, they definitely don't treat it as an or. I mean,
no, it's an and. They treat it as an and, which is contradicting their own guidance.
And when you look at the obligations that the employer has, I mean, once they sign that LCA, there's a lot of legal protection to the employer-employee relationship. I mean, they're required by law to pay the wages, and it's difficult to fire. I mean, you can't just, come in and say you're fired. You have to go through this bona fide termination process. So there's a lot of legal obligation on the employer to exercise that employer-employee relationship.
So, like in the reg, hire, pay, fire, or control. Legally, if you file the LCA and the petition, you're the only person with legal ability or legal authority to hire, pay, or fire that individual. So almost by statute, you are a de facto employer.
Right.
So the way USCIS is adjudicating these things has some significant problems.
So what's the solution? I got a cap case that's gotten denied. It's we've seen thankfully the more single issue denials. It used to be USCIS would tag in some extra issue to make it harder to appeal. I think they've gotten a little lazy on these, and now we're seeing these single-issue employer-employee relationship denials. So what's the plan here? Do I file an MTR or an appeal, or do we have another option?
You know, the MTR is something you're probably more capable of speaking to, but if you file it in court, you're going to preserve your chance to keep that H-1 valid. Mm-hmm. And I think that's the best option. And if we can file in court with a large number to show that this isn't just a one-off situation, that this is a huge systemic problem, it sends a huge signal to the court when you're litigating that we have to take this seriously.
Well, and when you consider, I mean, like you said, the MTR rates are around 3% success rate,
Yeah.
and the agency plays backstop to itself. The AAO is going to back up the agency. Filing in court, we are more likely to see the court to reverse that denial, right, than we are through the AAO or the MTR.
Yeah, statistically, your odds are better in federal court than on an AAO appeal.
And I think at that time you're getting a judge that understands how the law is written. It's not adjudicating officers who aren't lawyers.
Yeah.
And I think by going to court, you're getting a better place to explain that they're adjudicating this improperly and it should have been done this way. We shouldn't even have to be here.
Exactly.
So I think when you get these cap denials, we are looking to get together a big mass litigation on this issue, and the more that we can on these single issue employer-employee relationship denials. And like I said, when it's single issue, it's that employer-employee relationship heading with the subheadings of the right to control, that availability of work prong that they look at. Mm-hmm. And we can look at filing these as part of the mass litigation. If you want more information about this, feel free to contact us at Reddy and Newman PC, rnlawgroup.com, and reach out to any of our attorneys.